So this is a panel that I think ties in very well with the theme of our conference, which is the underreported. There was a sense among us that stories that are at the intersection of science and law are not really reported very well or not at all. And this is a bit unfortunate because the law is where the citizen really meets the state. And the law is very powerful. And the kind of narrative that sometimes you find in legal cases is something you don't find elsewhere. So it's excellent to be joined by three very interesting scientists and journalists for this particular session. It's so broad that that we'll need a way to sort of contain it, and we have a particular structure in mind, so we'll go with that. So some of the things like digital privacy and things like that, or like the Supreme Court's judgments on climate change, unfortunately we won't be able to cover. But let me begin by asking the panelists specific questions by which they can sort of introduce themselves. So let me begin with Thangarajan. We know so you've worked at CCMB, and CCMB under Dr. Lalji Singh has a tradition. Like, it was a surprise for me that DNA fingerprinting, and you can tell us about that India was one of the first places where DNA fingerprinting was allowed. So could you tell us about this background, and apparently it's been used in famous cases from the 1990s, which several of us would have read about in the newspaper, but we really didn't have that connection. So, yeah.
Yeah, thank you, Virat. Also, must thank Subra and the other organizers to inviting me to face a different kind of audience. We always face the scientific audience, but of course, it's a really good movement. The question which you asked about DNA fingerprinting, and India is one of the country which started adopting the techniques to solve some of the important problems. Of course, most of the findings which are application oriented comes from basic research. Same is true in case of DNA fingerprinting probe also. Alex Jeffrey found that the probe, which has a repetitive sequence, can differentiate every single individual based on the different kind of repeat motives which we all have in the DNA. In case of the probe which Dr. Lalji Singh has identified, it was again some time back which he found that there's a repeat called GATA motive, which he identified from the snake work, which is linked with snake sex determination. Right? So I'll be very brief because I can talk about it in elaborate because of time limit. So that was his finding, but when Alex Jeffrey found that the repetitive sequence can differentiate every single individual, then the director of Center for Cellular and Molecular Biology, Dr. Bhargava, he asked Dr. Lalji Singh, why don't you use it for similar purpose? And he found it's also able to differentiate every single individual, right? So that's how it came into fingerprinting aspects. As you said that India is one of the very first countries, in fact, third country in the world to use DNA fingerprinting to solve some of the really important cases, like the former Prime Minister Sri Rajiv Gandhi assassination case, the former Punjab Chief Minister Mr. Byan Singh case, Tandoori murder case, and many more such cases. So that's the background.
Right. I'll come back to that at the end because, all this science develops on top of, previous work. So, Rajeshwari, hi. So, I wanted to ask you about, you've worked extensively in, patent litigation. Could you tell us about, because to refresh our, uh, about the Gleevec patent and what your role was, and specifically what is a compulsory license? So could you tell us about, the work that you did?
Sure. Yeah, sure.
Sure.
Thank you so much, Shubhra, and all the organizers for inviting me here. Thank you so much. Great to have this audience here. So I'm Rajeshwari. I basically, primarily, I'm a patent litigator. I litigate cases across the country relating to intellectual property law, especially patents. So one of the good cases that we did was the Glyvic case. To tell you in short, there was this Glyvic is a compound which is used for treatment of blood cancer. So we are talking about the year, say around 2000, year 2000. So 95, Novartis already had a patent for this compound which treats blood cancer. This is called imatinib. They filed the patent everywhere in the world, but they didn't file the patent in India because at that time India had a process patent regime. So, and thereafter, we came into the product patent regime. We were transitioning into that regime, and they filed a process patent. And based on that process patent, because there was a transition which was going on in the law, so there was an amendment in the law which permitted Novartis to get something called an EMR, which is an exclusive marketing right, which is like a semi-product patent. And Novartis applied for it and they got it. And because we were in the transition stage, they didn't get a product patent per se, but they got EMR based on the process patent. Then what they did was to then enforce the patent across the country and try to stop all the generic companies who were trying to make this blood cancer drug. Important part of this was that the product of Novartis was being sold in the country at around 1.5 lakh rupees per bottle. And you needed to take it lifetime. It was for the terminal blood cancer patients. And the Indian companies were trying to sell it at around 6,000 or 8,000 rupees. So that was a lifesaver for the Indian companies. Now, the science behind it, we challenged the patent and we won at the patent office, we won at the High Court, we won in the Supreme Court also. And the Supreme Court laid down the law. What is 3D? Section 3D was, because by the time this matter came up to Supreme Court, we had changed into the product patent regime and we had already introduced Section 3D, which is a filter to ensure that we don't get frivolous patents in India. 3D is a provision which says that if there is a patent which is for a polymorph or a salt or something, it has to show enhanced therapeutic efficacy. In the sense, you have to show better curative effect. If there is a compound, that's the main compound which actually cures the disease in the body. And a salt or the polymorph, which is a variant of that, will only act as a vehicle to bring that drug into the body. It will not cure the disease. The curative element is again found in the main compound. So it's a window dressing of the main compound. That's what it was. Mm-hmm. And so they wanted to get they got a patent, they filed a patent for the polymorph. And that was rejected by the patent office on account of various oppositions. It went to the High Court and then ultimately went to the Supreme Court. And Supreme Court laid down the law that when you're talking about 3D, the efficacy which is referred there is therapeutic efficacy. So this was the long and short of that story. But the science behind it is with regard to the polymorph and the understanding of what efficacy a polymorph can give and what really efficacy means. Okay. So they were trying to, what Novartis was trying to show to the court and otherwise was that, look here, when I make this polymorph and when I make this tablet, it is much more stable. It stays on the shelf for a longer time. That's a commercial benefit. What is the curative effect? So that was never shown by Novartis, and that's how they lost the case. But the science behind it goes much deeper.
Right. Sorry, we'll come back to that.
Yeah, sure.
So also we have our third panelist, Zoya. So the theme of the conference is the underreported. And maybe Zoya, you can talk about some of the work that you've done and where, the law says one thing and, what you find on the ground is completely different. So the work that you did on, manual scavenging among women. Yeah.
So I worked on a story that was around women manual scavengers and increasing cases of hysterectomy among the community. So while I was pursuing the story, I did not know that there is a legal loophole in the definition of manual scavengers, because of which women manual scavengers still exist. So there are two types of manual scavengers. Men are assigned to work in septic tanks, and women are somebody who's assigned to work on dry latrine systems. So according to the legal definition on paper, government has so they have introduced or replaced the single pit toilet thing with the double pit toilet thing that doesn't require much of that doesn't require actually human much manual work for the double pit toilet system, but on ground it actually requires a lot of manual work. So because of that, they still exist on ground. They do not exist in most of the urban areas or urban, yeah, but they do exist in a lot of rural sector. Apart from that, another loophole is there is a law of rehabilitation of manual scavengers, which basically means that they do transfer a specific amount to these women manual scavengers so that they can carry on, or they can choose some alternative work from apart from this manual scavenging work. But when I went on ground, I kind of realized that the rehabilitation amount that they receive, because they belong to a particular community, either it goes in the repayment of loans, or either it goes in the for their health, or for their or for maybe even if they try to be there or try to do some different work, but because they belong to a particular community. For example, I met a women manual scavenger who got the rehabilitation fund. She tried to start her own milk business, but she wasn't able to because there was this untouchability angle to it, and people were not ready to take milk from her. So because of that, she's still supposed to carry on with the work. So on paper they are rehabilitated and they do not exist, but on ground they do exist. So I have to go through a lot of to and fro with the legal experts for this particular report, and then I came across that why still these women manual scavengers are existing but are not recognized. And due to that, then again the problem was there is no safety gear for them because they do not exist, and they carry on this work in a very bad condition as well.
Right. So you did file an RTI with the Indian Railways? And
Yeah.
could you tell us about that?
Yeah, so I did file an RTI because traditionally, most of the women manual scavengers were working with the Indian Railways because of the toilet system that was used in railways. So I filed an RTI to know if it is still existing, or if it is removed, or in 100% capacity of toilets. So yeah, so I did file an RTI for that, and I received a response in terms that it has been replaced 100%.
Right. So
with the
right. So there we see this, what often happens that you have so manual scavenging is illegal, right? There have been manual scavenging is illegal.
Yeah.
Right. So here we see that kind of tension between, what's written on paper and, what happens on the ground. And I think legal stories often have that, journalists call triangulation, but legal stories have that built in, perhaps. They have narrative, they have, data or lack of data, and then, you have what's on the ground. So the theme of the conference is the underreported. I wonder if I could ask Ms. Thangarajan about any aspect where you feel, that you've come across in your forensic work, which had a science aspect. And here I would like to say that, we don't, there is a privacy issue, but could you talk about the science aspect that you've come across in your forensic work that has been memorable or, kind of startling for you?
This is actually important in terms of public understanding of the technique. Fingerprinting can be done two aspects. One is for legal purpose, which the cases come from either court or police. Other one is a personal interest in terms of understanding between wife and husband. Then medico-legal, where the donor and recipient of, in case of organ transplantation, they should be blood relative. Only after confirming that, there will be organ transplantation will be done. So most of the cases which come legally, there's no scope for us to reveal what happened in that cases. But I can take some examples from the private cases. So in one of the cases where the young couple, they came for DNA fingerprinting when the mother was pregnant. It's a young couple. But the husband suspected, saying that probably the child is not belongs to him, or fetus is not belongs to him. Then I told him that when the mother is pregnant, we cannot take anything. Maybe come back after the child is born. Came back, we did the fingerprinting test and found to be he is the father. Then he could not believe that. Then he went back and brought the medical reports where it shows that he's having a condition called oligoacenoteratozoospermia. Means low sperm count, low motility, and a lot of abnormality in terms of sperm. Then we got worried. What is this kind of report? We want to test whether it's really the genuine report.
Right.
Fortunately, we had this computer-assisted sperm analyzer in CCMB. This part of LACO. So we did, and we found, yes, that's correct.
Right.
But still, for fertilization, just one sperm is sufficient, whatever the abnormality is there. So that's how it turned to be that he's the father. Then the science point of view, we wanted to analyze what actually happened. So much of abnormalities. We found scientifically one angle, we looked at the mitochondrial mutation, which actually, mitochondria, most of you, it's a powerhouse of the cell. It requires for particularly sperm, for sperm motility. We found there's a mutation which probably led to low motility of the sperm. Then we gave appropriate counseling and finally accepted, right? So that's kind of social justice can be done by giving appropriate counseling.
Right.
As a continuity of that, after a few years, he called me and said that his wife is pregnant again. So that means with it can be happened. You can unite the family with the technique. Right? So that's one angle.
Okay.
The second one, it's slightly different. Recently came from CDFD, where there's again organ transplantation.
Okay.
Father, mother, and the child. Because father wanted to donate the organ to the child. What happened in that case was that mother is the mother, but father is not the father. But father is somebody close relative of the family.
Okay.
Right? So how to report that? It's very difficult, right? So we confidently inform to the doctors that they are relative, but you cannot tell to the family, right? It will become too complicated. Okay, so these are a couple of examples. There are many more.
Right.
Thank you.
Right. Okay. So actually, I believe you've used sort of science-based arguments in courts. Again, could you tell us about? We briefly went through. But there's so many that you've done, like the rice patents or something more recent, where you've used the science-based argument in court. And I mean, I'm just curious, how does that does the court consider it? What happens?
Courts are usually, most of the judges in the courts are not scientific people. And some of them are actually commerce background, and we like law, so we are a little bit allergic to science. But now it's a little bit changing. If you get them interested in the science, they are willing to listen to it. So there are some cases where you need to tell a little bit about science to the court. So especially when we were talking about, there was a particular case we were doing where we were, it's about claim interpretation. So there is a claim for a particular patent, and then you are arguing that, look here, we are different. And in this particular claim, there was a particular herbal formulation. In that herbal formulation, there were 5-6 ingredients. And we were trying to argue with the court that in the claim which was made by the patentee, there were 5-6 ingredients. It's about an adhesive. So the adhesive works in a way, there are 5-6 ingredients which make up that adhesive. It works in a way that if there is a 5th ingredient, and that ingredient is the one which gives that coalescing property. So if you replace it, you can replace it with something else. But then it will give you a different kind of a coalescing property. It will give you an adhesive property, but that will be different, qualitatively different. And it is measurable. So we brought that to the court, and then we showed to the court that, look here, we are using a different adhesive ingredient. So we are, out of the 5, we are using a different ingredient, and therefore it gives you a different qualitative property, and that is why it is different. So it took a little bit of science to show to the court how we are different, and the court did appreciate that. There was another case relating to a pesticide. So there was one, in the public domain, people were using 80% of this pesticide. Then the patent which was taken by another party was for the 90%. 90% of that pesticide. So sulfur, it's relating to sulfur. Sulfur 90%, sulfur 80%. And they were also saying that I have micronized that sulfur. So sulfur 90% is micronized. Sulfur 80% has got bigger granules, so it will not dissolve, and therefore it is different. That was our argument. And we said, therefore, we are making 80%, it is bigger granules. We do not fall within the ambit of the patent. So we did one small experiment also in the court, because the argument which was made by the patentee was, even if I've said 90%, I've said 60 to 90%, so everything is covered within that. So what we did in the court was, we brought 2 beakers, and then we put the 80% pesticide into the water, and then we said, now take the clock watch and then see how much time it takes to dissolve. It takes 4 minutes. Now you take his one, and you try to dissolve it in water, takes about 1 minute. So this is the difference. And that's how the court appreciated that, these are 2 different things altogether.
Right. This reminds me of like Richard Feynman, that famous like O-rings experiment that, But so very interesting. And I mean, there was another part, I didn't know where else to put it in, but it's a little bit earlier, but it gives the kind of thing that is, interesting, that kind of narrative structure. So, you'd worked on the rice patent. So could you tell us briefly about that, about the basmati rice, and also just like when you needed documentation, where did you find it? Because it's a very specific.
So the rice check, so in our country, we have this basmati rice. It's a prized possession, SJAI. It's a registered geographical indication. Grows in the Himalayan region, in the northern part of India. And it's the climatic conditions. It's a combination of rice plant as well as the climatic conditions, which brings about that kind of a rice. And the important part of the rice is the rice which has that particular aroma. The aroma comes from one particular compound, 2-pyrroline, I think it is some pyrroline something, some compound is there in the rice which gives that particular aroma. And Rice Tech found out about it. So what they did was, this is a US company, they made a hybrid of the Indian plant, which is a long-standing plant, long-growing plant. It's a long plant, height is there, with their short plant. And they tried to create a hybrid plant. And that plant also had this compound, and then they filed a patent in the US for this particular plant as well as the seeds. Now, the reason why, now that was a patent in the US, we should all be very happy about it. Okay, it's a patent in the US. But it would affect all our rice exports because the patent was so wide that it would include each and every patent, each and every grain, whether it is a normal grain or even a basmati grain. And that's why the Indian government decided to oppose it. And we got it eventually revoked. But the science behind it was to go and hunt for documents. If you want to file a revocation, you need to find documents and show that this kind of a rice already existed in the public domain. So we had to go to all the rice institutes to gather the kind of documents to show that this kind of rice already existed, which has this spirulina compound. It has all the same characteristics, and therefore this patent couldn't have been granted because there was already information available in the public domain. So we went to the rice institutes, and when we went there and we asked them, can you give us some prior art public domain material to show that this kind of rice existed? They said, yeah, we'll give you this rice. Why don't you just experiment on it? That was really long ago, but then, of course, we had to undergo a lot of discussions with them, and then we ultimately got documents. We searched for their annual reports, which were filed way back in, say, around 92, 93. We got those kind of reports. We went into their dark rooms and we hunted for so many reports. And ultimately, we found some kind of Pusa was one of the varieties, and there were a few varieties which they were experimenting on. And they did have that kind of rice. It had few of the characteristics. Some of the characteristics we had to experiment on. We did that, and ultimately we submitted that document to the US court, and it got
Right.
revoked.
So, I mean, annual reports are important. Like, they can be, because usually, like, one doesn't they're there, but they're kind of kept on the side. But
Scientists, normally document keeping is the last thing that they like to do.
right.
Documentation is something they don't like. But they like to do research, which is very nice. But everybody needs to document the research, because if you need to eventually show that this is traceable, this kind of documents, then that's what helps legally.
Right.
So that's the lesson that the PUSA scientists learned, that we need to have. They had lots of field reports. I mean, tons of field reports. They had lots of reports, internal reports, but no date. There were lots of documents which they had no date. I couldn't use any of that. They were showing me, look here, look at this, I have this, I have that. But I mean, I can't use it. It has no date, no sign. Half of them torn apart. Terrible.
Right. So archives are important for scientific institutions. It's nice how it all connects. But okay, Zoya, I wanted to ask you about, this is still documented, coming to something very recent. So you have reported on mental health issues in, among women and children in Manipur. So this is, again, you would say, it's something that's underreported, without sort of, giving away any privacy. Could you tell us how you went about it? And are there any, what can science journalists or journalists learn from, can you tell us about how you went about it? And how does one report or find ways of getting information from conflict zones?
Yeah, so when I started, so it happened at the time of when that particular video of two women got viral. So it's just I just had a thought, maybe they must be going through some sort of, mental health issues. In fact, a particular, because when there is a conflict, women are mostly in target, right? So I wanted to explore that particular element, or that sector. So I started reading around, or trying to figure out if there are research reports around, because it's not something that is very fresh. It has been happening for a longer period of time. So I tried to look for such reports and research reports as well. So I couldn't find much much work done around this. So then like, because it was very fresh at that time, so there were like very a lot of logistical issues to go there and then trying to report around this particular issue. So what I did was, and then I was also not supposed, because I'm an independent journalist, I also had an issue with getting a permission to do a reportage over there. So what I did was, I tried to reach out some of my friends who were based in Manipur, some of the local journalists over there, and then I tried to reach out to the relief camps, then in charges of relief camps, and then I asked them to maybe if they can go through. I was just randomly asking them about, like, what are the people like in their relief camp going through, how do they react, and because they also don't understand mental health in that way. So I was just randomly throwing questions on them, and then I asked them to maybe if you can check your this thing, the visitors diary, if there is any health professional who's been visiting. So they went through that, and then they gave me a number of somebody who was based in Chennai, a like group of mental health professionals who were like visiting very frequently. So they prepared a report, and so they kind of like went there for on a regular basis within gaps. So they were like in the process of preparing a particular report. So it went for, I think this particular report went for a year. I kind of took good amount of time to report on this issue, because the health professionals who were visiting, they were visiting, then they were also like kind of trying to do online therapies. So this is how I went about this particular report. But there were a lot of issues in terms of like being able to connect with the survivors, being able to connect with the professionals, officials on ground, because it was ongoing. So yeah, so that was something that I like dealt with. So what I feel like is maybe reaching out to NGOs, or reaching out to local journalists or activists, or maybe local journalists are somebody who's of great help. Honestly, like I have done a lot of stories with the help of local journalists, first like figuring out things, how, like, what is the situation on ground.
So, but
And
how
then,
did this come to you? As in, like, why did you? I mean, it's in other way, it's sort of obvious that there would be PTSD among, but like, how did you go about when you like, why did you think that this was a story that would have all the pieces, or if it didn't have all the pieces, like, how did you, how did you decide to do this story? That
so as I said ki there was this video that was
Right,
particularly
right,
where
right.
a lot, matlab, it affected me a lot. So if it is affecting me a lot as a viewer, then I was very interested to know like what's going on in the community that is over there as well. There where there are, matlab, they are. So I wanted to speak to them. Actually, I wanted to speak to them. I had a lot of friends who were based in here, friends from Manipur who were based in Delhi. So I was like in a regular contact with them. I was trying to get a sense of them, from them, about their families.
Okay.
So yeah, so like I kind of figured out ki
Alright.
there was a lot of tension over this. So, and then like I wasn't specifically targeting PT, like covering PTSD or something, but as I told you, like it went for a year or something. So yeah.
Right. So again, there's this tension between, like, so PTSD, again, like, you probably won't find somebody, who'll easily label that, but you have that intuition, and then you go there and, you find,
Yeah, so I
what is
had an
happening on
intuition
the
that
ground.
there must be some sort of mental health issues going
Right,
on for sure,
right.
because there were reports around around therapies that have been like taken for children. So so that is why I reached out to, when I reached out to this particular Chennai based this thing team of health professionals, then they were like, because they were preparing a report, so they helped me
Right.
reach out or connect to the
Sure.
people who were dealing with PTSD. So yeah, that's how
right.
I went about it.
Right. So I think we have 5 minutes. So I'll just round off with 2 questions, and then we can go to the audience. Okay. So Rajeshwari, so like, we have all these, stories that we want to do, but how do we practically, like, what is the status of legal documents in in the courts, like what is available to us, what do we have to sort of get through people. So could you tell us about that? Like if I was a journalist, science journalist wanting to write about, some of these things.
So science can be the science is more involved in practically every matter except for some trademark matters or otherwise. But in sort of climate change matters or where government is or the courts are concerned with environment issues or otherwise. So science is definitely involved. So if you have oppositions which are decided by the patent office, etc., those documents are fully available online.
Okay.
There's no secret about it. The decisions and all the pleadings are available fully online. Anyone can access it and you can read it. And you can decode the documents with the help of some lawyer or some other people. As far as documents in courts are concerned, matters which are disposed of, which are over, those you can fully access as a matter of right.
Okay.
There's no difficulty. And now, as far as matters which are pending, courts will usually these documents are not publicly available, but you can talk to the parties and perhaps then acquire the documents.
Right. So this includes like PILs that not.
That's right. If that includes PILs, so you get the main story from the PIL. A lot of science is not articulated in the PIL by itself. A lot of science is to be understood or argued in the court. So if you go watch the proceedings and if you see the proceedings, that's one of the ways in which you can understand the science behind it and also talk to the parties. So if I'm filing a PIL on why all cars, including private cars, should be CNG or there should be a limitation on the number of cars, then the PIL will be a very skeletal PIL. It will just talk about CNG and then it will just briefly talk about that science and then that's it. Yeah. So it's not very helpful to us. But if we want to put out the science behind it as to how it impacts the environment, etc., then we ourselves will have to do that research and understand what's the impact of diesel-based cars or petrol-based cars and how it affects the environment and put that out. Simplify it, put it out to in the journals or in the newspapers, and it often helps because, especially when that CNG matter was going on, there was a lot of press around it. There was a lot of people who were writing about it, which made the judges also read about it, because the matter does not come in one day and then gets disposed of in another day. It just goes on for at least a couple of years. It's just pending for a long time, and judges, after all, are human beings, so they do read newspapers. And then when they read articles written about it and why they need to be really worried about it and they are the vehicles for bringing about the change, then they become affected by it and then they make the decisions accordingly. So it's always good to put out these kind of science-based articles.
Right. And also there have been lots of, there have been other sort of non-climate change also.
Yes, there are lots of such.
There are lots of, so in physics there have been, certain things that I've written about and other people have written about, which you don't necessarily get to sort of see every day. So, all right, so just to wrap up, Dr. Thangaraj, so could you tell us about this? So, if I understand correctly, CCMB was involved in this particular bill called the DNA profiling bill. So, could you tell us about the rationale for it, what some of the issues may be, and then briefly touch upon, next generation sequencing and what we can maybe, what we need to be wary about, but, what are some of the things that are very interesting about it?
Yeah, this DNA bill actually started at CCMB in the beginning. Then CDFD moved out of CCMB. Then CDFD spent a lot of time in drafting the bill and went to DBT. DBT looked at very carefully. Then it's sent to Parliament Committee. Parliament Committee has looked at very carefully. And they raised some of the genuine questions. And the question has been addressed in a proper way. That was during the pandemic time. Some of us have been called to go there and address all these issues. So basically the bill is about generate DNA profile of initially the criminals, then the public also to put in the database. Therefore, if anything happens, and if you want to quickly look at and to trace the individual, that would be of very useful. Then while it was going on, some of the parliamentarians, they raised question that this bill, if it is passed, probably that would help the government to discriminate some of the populations or the people. That was one of the main concerns. Of course, all of this has happened. Then all along, it was Department of Biotechnology which was carrying out this. Then one of the meetings, Honorable Home Minister suggested that it is the kind of custodian or something of Home Minister. Therefore, it has been transferred to National Crime Record Bureau. Because they are considered as a kind of guardian of all the database. Again, they have conducted few meetings when we went, discussed. They don't have any technical expertise. They said, we only will store the data. All the forensic laboratories can generate the data. CDFD can draft a SOP for operating the standard protocol for all the institutes. So that was the second level of discussion which was going on for a very long time. After that, again went to Parliament, then it has not been
But if you
passed.
could remind us, what was it? So it was to store the DNA, like.
They stored the profile, basically not in a digital way of the images which we get it, but convert that into numerical. Therefore, a lot of storage can be done. And that also is not very clear at the times how they are going to provide that information to all others, those who wanted to use it. So all these were not very clear. Ultimately, that bill has not been passed. That's the end of the story.
Right. Right. So, so I think we can open it to the audience for questions.
I recently got a certain interest in the legalities of science. I just wanted to know what are some laws we can look out for when we're talking about genetically modified organisms.
So there was a PIL on why genetically modified products should not come into the market. You can study about that. It's Aruna Rodriguez versus Union of India. You can look at that. And ultimately, the court looked at it, and then they decided that okay, we are not going to allow this. It was about a particular mustard crop, and they wanted to put it out in the market. It was a mustard crop which would have less odor and all that. But then they, Aruna Rodriguez and others protested and filed a PIL. So there are many such, PILs which you can study. If you want to talk about GMOs, you will need to talk about the GEAC, which is the regulatory body. And you will also need to look at the regulatory regime around the GMOs. And genetically modified organisms per se, that kind of science is still in the infancy now. We don't have those kind of organisms roaming, created and put out. We have more of research on the crops, because that's a lot of research which is going on, and we should not stultify that research. It's excellent research which is really needed for the country, because that's the kind of crops in the future that we will actually need. So I think there's a lot of things to be written on that. So you need to refer to some patent laws on that. Patent laws really don't prohibit it, but you probably will need to look at the regulatory angle, because that's a major hurdle for these kind of things to come into the market.
So there's a.
My question is for Dr. Tangarajan. My name is Srinivas Kodali. I write on privacy, surveillance, and I also track the NCRB. I believe the DNA bill has been stuck down, but they passed one more act called the Crime and Criminal Prevention Act of 2022, which still allows the state to store all of this information for 75 years or more. Now, I understand when you explain how they don't want to store the actual material, they want sequence DNA data to be stored. But has there been any requests to you from NCRB beyond, even without the bill, because they have one more act to do the same?
No, so far I don't know because I'm not part of it now because I superannuated and came out. But NCRB itself was not very clear because they don't have any technical expertise, even for storage. So we have given all kind of materials that what they need to do. So right now I don't have really any idea about what is happening there. Related to this particular sessions, so what science and law can do in terms of taking it to public, and also in terms of those who are communicating to the public. So any legal cases, I'm talking about human legal cases. So science actually can be taken it in such a way that so whatever you report is of 100% truth, right? And I think those who are doing such kind of science in the institute, they'll be always ready to help in giving the right kind of information. Of course, not in the judicial time, but beyond that, one can help. So that's what is my final word.
I would just say that when we report around a particular issue, we mostly tend to ignore the science aspect of it, or or the legal aspect of it. So sometimes it's good to, maybe if there is some sort of conflict or some sort of a issue that is going on for a while or for a period of time, maybe it's good for a journalist to maybe go through or refer to some legal experts or research papers, or maybe come with a science aspect of the issues as well, because a lot of time it's the science aspect of the problem that goes underreported. So yeah, that's
Right.
Yeah, I also agree with Zoya, especially in matters which are related to patents and all. I think a lot of science doesn't get reported at all. We only see the big picture. Oh, so and so has filed a case against so and so, price has reduced, anti-tubercular drug patent rejected. But the science behind it is very important. You see why really India rejected it, because there are lots of some articles are like this, anti-tubercular drug, India rejected it. Some articles are like all over the world it was granted, but why was it rejected in India? Why? So did the Indian examiner become a super brainer, or were the Indians some kind of super scientists that they didn't decide? They decided that this is a nonsense patent. Why was it actually rejected? That science must come out, and it must be put out in a very simplistic manner that the people can understand that, okay, this was what it was. Oh, this was so obvious. This was so evident. So that little bit of, it's like an explainer, some people were saying, a little bit of an explainer, a little bit of explanation for the common man as well as for people around to understand why these rejections happened or why those patents succeeded. If we granted patents, then why did those patents get granted? Some patents are granted on machines for producing oxygen or oxygenators. So then why was they granted? What was the improvement that they did? And how you can encourage such people. There are some startups, how you can encourage them. What was the science that they discovered? So that kind of science, if you put it out, that will really help. People will get educated. That it's not a big deal. I mean, that science which you are talking about is not a big deal. It will be just about 2 or 3 paragraphs. But that 2 or 3 paragraphs will really turn the story around.
Right. All right. So thank you so much to the audience and to the panelists.